Governor Charlie Baker is taking another run at a controversial proposal he says would help people addicted to drugs get the help they need. And just like last time, it seems the legislature might need some convincing. His latest package of reforms includes a proposal to expand the state's civil commitment law to allow medical personnel and police officers to hold drug addicts against their will for up to 72 hours if they pose a risk to themselves or others without needing to get the okay from a judge. If the measure passes, it would take effect in 2020. Now, this isn't the first time the governor's put this controversial idea forward. He also floated it as part of an opioid plan he introduced in 2015, but the language was removed from the final bill. Last week, the governor testified before a state committee and emphasized that this is just one tool in the toolbox to fight opioid addiction.
By the time somebody has overdosed multiple times, they're the equivalent of somebody who is right on the edge of not surviving their illness.
But critics say forcibly holding addicts would be a violation of their civil rights that could put them at an even higher risk of overdosing. Joining me to discuss are Matthew Segal, the legal director for the ACLU of Massachusetts, and Woody Giessmann, an addiction specialist and the founder of the treatment program Right Turn. Thank you both for being here.
Thank you.
Woody, let's start with you.
Yes.
Why, from your vantage point, doing the kind of work that you do, would this be a good idea?
Why would it be a good idea? Well, first off, I just want to say it's wonderful that we're having these conversations about ways to look at the systemic issues around substance use. And having Charlie Baker and Secretary Mary Lou Sudders leading us through these conversations, it's adding another tool to our toolbox, one that I hope is not misused or abused, because we don't want to put the fear into people that if they present in an emergency room that they might be held against their will. But it would give us an opportunity, if we had a huge concern about someone, to be able to observe them for up to a period of up to 72 hours.
And try to get them to engage in voluntary treatment to the extent that you can engage in voluntary treatment while you're being held involuntarily, right?
Correct. It's an opportunity to have some form of intervention, some form of a conversation with an emergency room physician or others and that might effectively save a life.
And would you imagine this, I swear I'll get to you in a second, Matthew, but would you imagine this being used primarily after someone has been revived from an overdose? Is that the likely scenario that this would be used in?
I would most likely, yes. If someone had presented at an emergency room a number of times and had been they've used Narcan to revive them from an opioid overdose, yeah, they would be someone that might be considered for something like this.
Okay. Matthew Segal, what is wrong with suggesting that when people are at a point of maximum vulnerability and have maybe just avoided death because they were revived by Narcan, that they might need to be held against their will and treated in some manner for 3 days. Involuntary commitment, as you know, is already legal if you go through a judge for people in situations like this. This would make it easier to put people in there. So what's wrong with the approach that we're talking about here?
Well, first of all, there's a lot of things in this bill that are quite good, that seek to enhance high-quality treatment, that seek to avoid, tell people avoid becoming addicted to drugs in the first place.
You're talking about the governor's big new omnibus opioid.
Right, but in terms of this 72-hour hold, it's true that people might be in real peril. But at the same time, this provision not only can imperil their liberty, it can imperil their lives.
Tell me why you make that argument, or what it is that makes you say this could make things worse rather than better.
Well, the clip you played from Governor Baker talked about people on the edge. And so it's true that when people are on the edge, we want to make sure we don't push them over the edge. But holding people involuntarily can do precisely that. It can present a cure that's worse than the disease. And the way it can do that is by forcing someone into detoxification without really meaningfully addressing their addiction. So then they're released back into their lives, potentially, with no real reduced addiction to the substance that brought them into the ER, but with a reduced tolerance for that substance, and that can be the thing that pushes them over the edge. So we understand that people who are proposing this legislation want to do something, but this is a situation where this provision can be worse than doing nothing at all.
What do you hop in and see?
So what I think I hear you saying is that if you hold someone who's in active addiction for a period of time, that when if they're released, that they might be at higher risk for accidental overdose, for going back to picking up substances, opioids, and it might result in an overdose.
That is what I'm saying, but I'm not the only one saying it. The Commonwealth's own data from its Department of Public Health says that people are approximately twice as likely to die if they undergo involuntary treatment as opposed to voluntary treatment. So it's not just the ACLU saying it, although we agree.
Yeah.
It's the state's own data that's throwing caution into the situation.
Sure. I mean, and it's an interesting piece, and to me, the conversation around the workforce and who in the emergency room is handling this. Are we expecting physicians to be doing more in the emergency rooms? Are we providing the physicians with more support? Often physicians are not well trained or have support around treating substance use disorder.
That's not what they're trained to do, presumably, yeah.
Right. So it raises the issue around the workers in the emergency room.
Well, Woody, let me get you to weigh in on this point Matthew brought up. If I understand it correctly, you're suggesting that when people are treated involuntarily, they may have a diminished threshold, chemically speaking, right, for experiencing a lethal overdose after they're released. Is that a fair paraphrase?
Right. They have a reduced tolerance for the drug to which they're addicted.
So is that a concern, Woody, for the people
I
you
would
work
say
with?
that would be a concern, and that we don't want to misuse this 72-hour hold and make people, first off, maybe resistant to coming into an emergency room and asking for help when they need help, or leaving a 72-hour hold and being at higher risk. So we're in agreement.
Okay, let me hop in. I want to make sure that we remind people of the stakes that we're talking about here. I think we've got some visuals that point up the lethality of the opioid epidemic here in Massachusetts. Let's take a look. Running up to 2017, September 2017, going back to January of that year, nearly 1,500 deaths. That's down from the previous year. And when people have overdosed, they frequently end up succumbing to a fatal overdose down the road. I think we have a visual there as well. I hope. There it is. 1 in 10 addicts revived by naloxone in Massachusetts die within a year. Matthew, there was a similar proposal, as we mentioned, that the governor made in his first big opioid bill back in 2015. Even though you don't like this current proposal, is it better in any meaningful way than the last time the governor proposed it?
I'm not sure that we're perceiving much meaningful improvement, again, in this one provision that is amid a larger bill that has a lot of really good things. And I think that what's the bigger picture and what's really important about this particular provision is that I think in Massachusetts we hear everybody, Woody's made the point, it's good we're having this conversation. So we hear everybody saying we need to be for a public health approach to the problem of drug addiction. And I think to really be for it, we have to be against anything that resembles an incarceration or a punitive approach, and that's what we're worried about with this provision.
Let me press you on that a little bit, because I know the argument that Governor Baker makes is by taking involuntary commitment out of the courts where it currently resides now. If you have a family member who's struggling with addiction, has just overdosed, you need to go to a court to get them involuntarily committed. By allowing not just police officers but medical practitioners to make those involuntary commitments, that it would aid in the destigmatization of addiction. That's the governor's argument. What do you think he's missing?
Well, it's hard to say that we're avoiding stigmatization entirely if we're forcing people to do things against their will. And to my ears as an ACLU lawyer who believes in civil rights, we're not really adding any meaningful health benefits there by removing the courts. We're just taking away due process.
All right. Woody, go ahead.
Well, I would ask you to look at what they do in Florida, the Marchman Act. Are you familiar with Florida is one step ahead of us. What we have is a Section 12, which for mental health is a 72-hour observation. In Florida, they call it the Baker Act. They also have used the Marchman Act in Florida to use this hold for people who might be at high risk for substance use disorder and accidental overdose. So it's already been, this is something that there is a little bit of data that would support this.
And you think it's working well in Florida?
I would say, well, is it working well? It's working. It's being utilized. I hope it's not being misused or abused and holding people against their will and creating more resistance.
Matt, I think you wanted to weigh in on what he just said.
I think Woody's absolutely right that we should be on the lookout for data that can help us. But again, there is data that already exists in Massachusetts, and I think we really have to guard against this impulse that we need to do something and to latch onto anything that might hold promise, because people really are suffering, and we don't want to sell them snake oil.
I want to ask a question at the end that I could have asked at the beginning. Can you just describe for people watching at home who don't have experience with this directly, like you do doing the work that you do, what do you feel like physically and mentally after you have perhaps just been revived from an overdose that could have killed you? What does it feel like to be a person in that situation?
Well, I mean, that's an interesting scenario, because if you do have someone who has been, we've utilized Narcan to revive them, right? And with the use of fentanyl these days, it's not just one shot of Narcan, it's sometimes 4 to 7 shots of Narcan. Now we have a window of time where they're going to be revived and at risk for going back into so they're going to be in a, to answer your question, I think what we expect is for them to come out swinging and saying, why did you take away my high? You know, and they might be irritable in that way. And so we have to be, we have to be careful.
Not necessarily in a position where they are capable of seeking out the treatment that they probably should be at that point.
Correct.
Okay.
More the reason for, and I think Secretary Sutters and Charlie Baker have introduced this notion of the workforce and introducing people. I hope I'm not getting ahead of you here.
Well,
introducing people like myself.
Yes.
And I'm happy to say I'm someone with long-term recovery.
Yeah.
You know, 27 years of my own personal recovery, and introducing this concept of increasing the workforce in emergency rooms.
Got to wrap it up there. Woody Giessmann, Matthew Segal, thank you both.
Thank you.